the idea, right? There's what I'm saying is that when you take that amount, that loan amount, and you put it in context of $34 million that Myman has received, there's no indication that Dr. Toledo had knowledge of the flow of the money. There's no indication either that there's certainly nothing reliable that Dr. Toledo directed how Myman moved the money around. Now, the properties purchased in Peru were, according to the nominee agreement, completely controlled by Myman. And so what I'm asking the court is to say, look, there's common sense here that says if Dr. Toledo were in fact knowingly receiving the proceeds of Myman's crimes, then Dr. Toledo, one, has to be aware of them. And common sense says that Dr. Toledo would be asking for a lot more than $500,000 to pay off mortgages in Peru when he was suffering from interest rates that ranged, I think, up to about the 15% rate. And so it doesn't make any sense that a crime occurred and Dr. Toledo had 30, I think Myman claims at different points that he was going to take a commission of about 10%. So let's say that under Myman's, under Myman's perspective on it, he's taking his commission, and then 31% is supposed to go, or $31 million would go approximately to Dr. Toledo. What happened instead is documented in the financial records. It's documented in Myman's cooperation agreement, which is that Myman funneled the money to his family. Myman spent a bunch of the money on himself. Myman funneled it to his other companies. And Myman—
I have a question about that. You're allowed to introduce evidence that explains the government's evidence, but you're not allowed to introduce contradictory evidence. There are 2 points in Myman's statements in the extradition request where he said that he didn't benefit and didn't receive any cash and didn't profit personally from this whole series of transactions. And now the judgment of effective collaboration and then the cross-examination of Myman by defense counsel in exhibits G and H. Well, the judgment of effective collaboration indicates that money did go to Myman personally. And then the cross-examination leads to Myman basically admitting that he skimmed off about $13 to $14 million for his own benefit through transactions to friends and family. Is that evidence contradictory of the government's evidence?
So, Your Honor, I think first, I think that is, I think the government misunderstands the standard, because I don't think it's not that the court is not permitted to consider any evidence which bears on the credibility of the evidence before the court, the credibility of the witnesses. That case law is there, as the government indicated, to prevent a mini trial. What is being presented to the court here is evidence that has already been collected by Peruvian officials. These are bank records not sought by the defense. These are bank records that have been it wasn't a subpoena process from the defense. This is the Peruvian government tracing the money and finding, as they incorporated in the cooperation agreement, that Myman had kept the money for himself. And so I think it would create an absurdity to say that the court is barred from considering evidence that shows inconsistency in what has previously been presented. I mean, it would make a fool of the court for precedent to be considered that would prohibit the court from considering reliable information submitted from the requesting country, information gathered by the requesting country that contradicts other evidence that was presented previously. And so, to the extent that the government has been able to sort of quote unquote update the court with new information that wildly contradicts the information that was set forth in the original complaint, it would be ridiculous for the court not to be able to consider evidence that it's also certainly explanatory as well. And the court's also allowed to consider that testimony may be self-contradictory. So explaining what happened to the money, even if it conflicts with a statement given by the witnesses, it is certainly within the purview of the court. And again, the court absolutely has the ability to consider the credibility of the witnesses, and so explaining the path of the money. And the government, as far as I can tell, is not contesting the authenticity of the records, nor the defense's summary of those records. I understand the government saying that they have not gone through and checked all the bank records to verify it, but the government is not contesting the authenticity of what's being presented to the court.
Well, let me ask you, I think now you're referring to the 2,195 pages of financial documents that the defense manually filed. Because the task would be overwhelming, I have not compared all 2,195 pages to the other financial records that are already in the extradition request or the supplement to the extradition request. Do you know how many of them are already in those records? Or like, if I were to admit the 2,195 pages, what would be added to the record? That's what I can't figure out.
Sure. So I think what we did, and Caitlin Costello, the paralegal in our office who did the financial summary, did a fantastic job and reviewed the records. I can't give you a number off the top of my head in terms of the additional transactions that are reflected in our manual filing. But what we realized is that we could tell that this was not a complete financial picture that was being presented to the court. And so our summary reflects what we understand to be a complete record of the financial records that have been acquired by Peru from the Swiss banks and other sources. And so what it shows is a more accurate presentation of what actually occurred in terms of the transfers of money. And one of the things we wanted to present to the court for that is that the complaint originally, which has already been basically superseded or contradicted by the government's own submissions subsequently, the complaint was not accurate at all about where the money went, where the transfers occurred, and whose benefit they were for. And the complaint states absolutely incorrectly that basically 20 million was transferred to accounts in Dr. Toledo's control, and that's just not correct. The bank records show, they explain the path of the money, and they show the actual control over those accounts. And without any exception, the ultimate control over all of those accounts rests with Joseph Myman, whether it be through holding companies that he created, whether it be at the direction of his attorney or other employees in his company. There's no allegation that Dr. Toledo has control over those accounts. And so,
well, let me ask you this then. After the Odebrecht scandal breaks, then Myman and Toledo become adverse because Myman agrees to be an effective collaborator. So he's basically turning state's evidence against his friend of several decades. But before the scandal breaks, why is it necessary for the money to literally end up in a bank account that has Toledo's name on it? Why isn't it good enough to get the money in the hands of his mother-in-law or his longtime friend, Myman? Why isn't that good enough to effectively put it into his control? I understand that once Myman severs connections with Toledo, then it makes a world of difference whether the money is in Myman's hands or in an account controlled by Toledo. But I'm talking about before that happens. Wouldn't it, in fact, be preferable for Toledo not to have all of that money actually end up in an account that he literally controls, but have the friends and family plan where the money is near him and available to him?
So on this record, there's not evidence that the money is available to him, nor that he had knowledge that the money was something that Myman had collected from Odebrecht. The money being in the money being briefly under the name of his mother-in-law is the theory that causes it to be somehow for Dr. Toledo's benefit or under his control is out the window because of the nominee agreement. That is in name only. It is something maintained only by Myman. So what the question then, I guess, would be, where is the actual evidence of knowledge, and why would Dr. Toledo not be spending that money or requesting it? And that's the really interesting thing is that Myman does not testify because he cannot testify to Toledo demanding the money from him. I mean, that's sort of what there's this assumption that simply because Myman requested the money and that Myman was considered at a time a friend of Dr. Toledo because he had ingratiated himself to Dr. Toledo when he saw that he had political promise, that would make sense if there were actual transfers of money. And I understand the court's sort of suggestion that this is a friends and family plan, but that has practical limitations. That money, the idea that Dr. Toledo, who is coming up on age 76, was sitting around for a decade plus and having no concerns about the fact that these tens of millions of dollars that he supposedly risked his career and his freedom to extract from Odebrecht, that those could just sit around. Why wouldn't they be spent? I mean, that's the sort of common sense practical question here is, why are we assuming, the government's asking the court to take this leap and this assumption that Dr. Toledo is aware of the money, but yet somehow was this extraordinarily patient criminal that would be fine sitting around into his later years, working his butt off to get jobs as a professor, to write his second book, and living a very modest lifestyle, while not complaining at all that Myman was hanging on to all of these 31 million that was promised to him. Myman has no explanation for why he claims that he was owed a small commission and then is now admitting that he actually spent 14 plus million on himself. And the reason is that it doesn't make sense. The only fact pattern that this fits with is that Myman separately negotiated with Barata and claimed that certain goals would be met. Barata himself testifies that those goals weren't met. They were reasonable, practical goals that could have been met by accident through Toledo's actions as president.
To your point about Toledo being a very patient criminal, once the Ecoteva scandal breaks in 2013, doesn't everyone just panic that the Odebrecht scandal is going to blow open soon? Wouldn't that be a deterrent to further transfers to his accounts?
Well, I mean, it could, but we're talking about years where the only transfer is, so presidency ends, and we're 2006 on to 2013, and the only transfer is the exact amounts that are outstanding in these predatory loans that Dr. Toledo is suffering under for his mortgage.
Odebrecht paid very little bribe money while Toledo was president. It was only $4 million. They keyed the turnover of the bribe money to the construction of the interoceanic highway and their receipt of funds. And most of that happened during the Garcia administration. So the money was paid out between 2006 and 2010. So it's really not that long a time before the Ecoteva scandal breaks and everyone freaks out.
But again, Your Honor, I disagree with that evaluation of that timeline, because you have 4 million during the administration, and then you have the balance paid 3 years prior to the Ecoteva issue, during which time, why would a week pass? Why would 6 months pass? Why would a year pass? Let alone, why wouldn't the 4 million be dispersed immediately, minus Myman's supposed 10% commission when it was received? It doesn't make sense. We're not talking about a matter of weeks. I mean, we're not talking about. So I understand the court's concern that there may be, a sort of a freeze of activity, but it's not consistent with when the money was paid, and it's not consistent with what the expectations Toledo would have if he were a party to this agreement in any way, or even aware that it had happened behind his back. So I don't think that.
What are we supposed to think, though, about the money that went to Toledo to pay off the mortgages on the house in Camacho and the house in Punta Sal? He's just, my friend loaned me $500,000 and Thank you. That's great of you to loan me $500,000. We're not supposed to think, well, he might know where that money came from.
No, of course. So certainly not. And I think the things that are indicative otherwise are, one, this is a tiny drop in the bucket compared to what was paid out to Myman, right? What was supposedly a portion of the agreement. So let's take the government's theory at face value for a second. Toledo is the architect of all of this, right? So for the money laundering theory, Toledo is the architect of all of it, and he directs all these shell companies that are obviously Myman's actions. But the government's allegation is that he, in violating money laundering statute in Peru, directed how and where this money was to be moved, in spite of there being no evidence of that. And then let's take at face value the collusion allegation. The face value of the collusion allegation is that Dr. Toledo was the architect of a corrupt agreement to accept $35 or so million in exchange for doing certain things to ensure that Odebrecht would be the recipient of the contract. So taking those at face value, then we step back and we say, okay, Dr. Toledo then knows the exact amount of this agreement, right? So he knows that he is supposed to be receiving $35 million. And so some number of years later, he asks Myman for a loan to pay off 2 properties, not more than the amount of the properties, but the amount of the mortgages outstanding on the properties.
Well, but his mother-in-law ends up with a lot of this money, at least in her name. You can dispute whether she has control, but it got pretty close to him.
So the mother-in-law was the mother-in-law did not have actual control over it, let alone Toledo having actual control over it. And it wasn't her money in any real aspect. She was used as a name for tax purposes for Myman. And as is indicated in Myman's testimony, he had a direct contact with her. And so getting close to something when all of the indicators otherwise point the other direction is certainly not enough to establish a crime. It's not enough to establish probable cause that a crime occurred. But I'd like to sort of complete the analysis since we're looking at the government's allegations. You have this $500,000, and this is somebody that is Myman has ingratiated himself with Toledo. He has held himself out to be this sort of illustrious billionaire with projects all over the world, as is very clear in the record. He had prior dealings. His testimony is that he had prior dealings with Peru, that he had been involved in these hundreds of millions of dollars of currency transactions, disguising the location or the source of money to pay down debt, and being this intermediary for countries and moving millions of dollars around the world. That's his public persona. That's what he holds himself out to be, and that's how he ingratiates himself to leaders like Dr. Toledo. But in doing so, the idea that he could loan Dr. Toledo $500,000 out of his supposed hundreds of millions or billions of dollars of personal net wealth, when Dr. Toledo is suffering with a modest income in the United States and these extortionate interest rates from the mortgages in Peru, the idea that would show that Dr. Toledo was aware of this massive agreement, $35 million, why he would be asking for basically just some relief from predatory mortgages doesn't line up with the knowledge of someone who understands that they have $30 million coming to them. So I understand that there's concern about it. Obviously, in retrospect, if he'd had any idea that Myman had secretly collected tens of millions of dollars, he wouldn't have associated with him. But it's evidence that, while at first blush could be considered suspicious, but when taken in context of the total amounts of money involved here, and if you look at face value, the allegations against Dr. Toledo for collusion and then money laundering, the idea that the money laundering allegations are that Dr. Toledo directed the flow of funds, which would necessarily require that he knew where the money came from. He knew and directed the flow of it through Maimon's shell companies. But then at the end of it, at the end of directing all of that money and supposedly committing the act of money laundering, he stops short and doesn't ask for it to go the step further to actually transfer him the money. That doesn't make any sense at all. And that's what obliterates probable cause. Just as much as the contradictory testimony, internally contradictory testimony, absolutely incredible testimony of Maimon and Barata are not available or not sufficient to establish probable cause. It's common sense that buttons this up and absolutely obliterates probable cause in the end. Why would someone risk their life to solicit $35 million in bribes and then not deliver on the supposed promise and then not ask for the money once it's been paid? None of that makes sense.
Let me ask you this, and I apologize if this is an unfair question, and you don't have to know the answer. What does a trial in Peru look like? For example, would Barata and Maimon have to testify?
My understanding is that they would have to testify. I think that my understanding, and I cannot profess to be an expert on this, is that their deposition testimony under oath so far is what would be presented to the judge to eventually issue a formal charging document. And again, I think it may not be relevant to the probable cause determination, but I think it's important for the court to know that shortly after the court denied our motion to dismiss for lack of a formal charging document, the Peruvian authorities moved the case back into the investigatory stage, and that's where it is today. So again, as we indicated in our briefing, there is still not a formal charge. It has not been presented to the court for formal charge. The intermediary stage.
But it's your understanding that Barata and Maimon would have to testify in a trial. They couldn't just show the transcript of their prior testimony.
I believe so, but I'm not an authority on that. So.
Oh, okay. I mean, it'd be a long cross-examination. There's no doubt that there would be a lot that the defense lawyers could explore with them.
But Your Honor, if I could draw the court to something that the court deals with possibly even on a daily basis, and that's the decision about whether to issue a warrant based on probable cause. As the court is familiar, every time informant testimony is presented in either a complaint or a warrant affidavit asking for either the issuance of an arrest warrant or a search warrant, there's a determination of probable cause. And there's always that footnote that is dropped, which says, this information is provided by an informant. I have a basis to believe, because of their prior good information, that they, in spite of the fact that they are either being paid to provide this information or working off another case, that they're indicia of reliability based on that. If the court were presented with the testimony of people that were constantly contradicting each other and had already been determined to be not credible as to material aspects of an agreement. And again, I disagree with the court's sort of characterization of Barata and Maimon's contradictory statements as to the agreement. This agreement, the aspects of the agreement, Dr. Toledo's knowledge and input in the agreement is the only thing that would make it a crime on Dr. Toledo's behalf. Again, the government is correct that we're not arguing that no crime occurred here. Absolutely, the evidence establishes probable cause that a crime occurred on behalf of Maimon and Barata and Odebrecht generally, as well as a number of Maimon's associates. But the contradictions are relevant to Toledo's knowledge of the existence of that agreement, let alone his input into that agreement to direct the agreement. So if the court were considering this in a warrant application, I would certainly hope that the court would have extraordinary pause in issuing a warrant where the only evidence is contradictory evidence presented by people who have been found to have lied under oath, contradicting their own statements under oath over and over again. And so in that sort of, in that day-to-day consideration of a warrant, this would be, especially with what the government is objecting to the court's consideration of, which is, I can't imagine a situation with the government's Brady obligations in the United States where they would present an affidavit to the court, including informant testimony, but then either learn about later or know at the time that there was contradictory evidence, that there was much more testimony, and then not present that. It would be savaged in a Frank's challenge to a warrant. And so I think in that kind of analysis, this presentation to the court, it's not just some allegation that a crime occurred, but there has to be probable cause to believe that the crime occurred. And when you have witnesses that are just so fundamentally unreliable, and not on minor details, not on discrepancies or minor inconsistencies, as the cases that are cited by the government describe, but absolutely fundamental underpinnings of this agreement. And then you look at what actually occurred, the practical sort of extrinsic evidence of what occurred, when the money was transferred, who it went to, and the relative tiny amount that went to Dr. Toledo, as well as the absolute lack of demand by Dr. Toledo of any of these finances. The only conclusion that can be drawn is that Dr. Toledo was unaware of this agreement, had no benefit, and took no action on behalf of Odebrecht outside of what he was doing otherwise as a president. And so it seems that it's well short of probable cause. It's bare allegations unsupported by the evidence submitted by the government, and certainly unsupported by the complete record, which has been submitted by the defense.
Alrighty, thank you, counsel. Let me hear from the government. And one question I would like the government to address is that in Exhibit G, Maimon seems to flat out admit that he skimmed off about 1/3 of the bribe money for his own benefit. And I see that Peru certainly did not include that testimony in the evidence it submitted to the United States. Does the omission of that evidence and the content of that evidence show that Maimon is just completely untrustworthy?
Thank you, Your Honor. I'll start with that question. No, it doesn't. I mean, certainly the story of where all the money has gone has evolved over time. And that is due in part to the fact that initially the documents showing the money trail hadn't been reviewed or presented. And so once those documents were produced, the allegations were crystallized more clearly. But regarding whether the money went to Maimon or how much money went to him, it doesn't change the allegations that some of the money was used to purchase properties that have been tied to Toledo. The allegations regarding Maimon's money don't change those allegations about the properties. And they don't undermine Maimon's credibility as a witness either. I mean, I think it's not unrealistic to think that a witness might change his story about how much the bribe money he was receiving. And indeed, Maimon explains that there are some inconsistencies about his connection to the money. You know, Your Honor was asking about Ekateva earlier. And Maimon says in his 2013 testimony that it was his company and that he bought the properties that are at issue in this case. But then in his later testimony, he explains that, well, actually, as soon as the Ekateva scandal broke, Toledo came to him asking for help. And that was why he claimed the company and the properties for himself. But in fact, that he didn't actually know about the property of the company until he read about it in the news. So there has been an evolving story in terms of exactly what Maimon has been doing to help cover up this bribe. But certainly there is no evidence that even if Maimon received 1/3 of the money, that money also wasn't going to Toledo. An example of this would also just be the loan, as Your Honor has pointed out, which even if it was a loan, although I don't know that we have evidence in the record to show directly that it was ever repaid, it still shows that Toledo was benefiting, at least in some way, from the Odebrecht money. If I can just address everything that was just said, I think you can pretty much only accept what was just said if you find Barada and Maimon's statements not to be credible, and that's something the case law prohibits. So the court in Colmar, which is a case from this district, expressly says that extradition fugitives have no right to attack credibility. Similarly, the court in Santos explained that fugitives can't offer evidence that would contest the credibility of original statements. And it cited to cases from the 7th Circuit and 2nd Circuit that say that extradition courts should not be making credibility determinations. You know, there's been a reference to a comparison with obtaining a US warrant, but that's not the case what we have here. I mean, there is still a sort of preliminary examination of the evidence, but in an extradition case, the criminal case is in a foreign country. That's where all the evidence is. That's where the trial is going to go forward. And so credibility determinations should be reserved for that forum. But in any event, the statements that have been provided by Barada and Maiman are in fact credible. I mean, they're providing firsthand accounts of events that they themselves eyewitnessed and are admitting that they in fact participated in. They provide myriad details. Their accounts are also generally corroborated by other evidence in the package, at least to some extent. So the inconsistencies that defense counsel has complained about are minor. If you look at the big picture, both Barada and Maiman agree that there was a bribe agreement that was reached toward the end of 2004, that Odebrecht paid money pursuant to that agreement beginning in 2006, and they're both quite clear that it was their understanding that the money was intended for Toledo. Regarding the bribe meeting, what the evidence shows is that there wasn't just one meeting where the bribe was consummated. It was a gradual process that was the product of a number of meetings. So it's also not correct that, as defense counsel claims, Maiman says that there was no meeting to discuss the bribe. There's no such express statement that I'm aware of in the record. He discusses a few different meetings that are held in Rio, and he doesn't clarify that the bribe was discussed at them. And I think there's one meeting when he specifically says that the bribe wasn't discussed, but he's conflated a bunch of different meetings in his filing, and again, he did so today. And as the court noted, Maiman himself may have jumbled them a little bit as well in his own memory. Just to respond briefly to the point that Toledo's actions were not those consistent with a sitting president, well, there's evidence in the record indicating that witnesses say otherwise. There are witnesses who testified that Toledo's participation in the tender process by holding meetings in the government palace and asking only about the highway project and not the other public works projects being discussed at those meetings, seeking to shorten the time frame for the project. Witnesses say that that was not usual conduct. Meetings that were held at the government palace, both for the pro-inversion board meetings and also there's the log from the government palace that documents meetings between Toledo and Barada. I don't think it's necessarily clear that meetings between a sitting president and the head of a public works project were a common occurrence. I have
the same reaction when you talk about Toledo's conduct as when the defense talks about the Toledo's conduct, in terms of his participation in the project, which is kind of, so what? I mean, he can be an idiosyncratic president. He can, have lots of meetings when other people wouldn't and push forward projects that other people might not have pushed forward. The issue is just, was there a bribe? And that, so I don't know, that doesn't strike me as very persuasive that the things that he did in office to push the project forward, there could be all kinds of reasons for that. The issue is just, was there a bribe? And even if he might have done the same things in the absence of a bribe, it just kind of doesn't really matter.
Agreed, and I think it's certainly consistent with the bribe agreement at the very least. Regarding the claim that it's not possible that Toledo didn't know about the agreement, that's just not possible if you take into account Barada's testimony saying that he personally was delivering cash to Toledo and that Toledo was pressuring him to continue payments of the bribe money. And it's also not consistent with the trail of money that filters to properties that were unquestionably purchased by Mr. Toledo's mother-in-law and that were also linked more directly to Toledo given his involvement in those purchases. Regarding the laundering of the money, the fact that Maiman receives some of it, I mean, he forfeits only 5 million of it in his cooperation agreement. And, as I said, I don't think this detracts from the fact that Peru claims that other money went elsewhere. And that's really the meat of their laundering claims in terms of linking it back to Toledo.
Let me ask you a question I posed to the defense. The judgment of effective collaboration makes clear that Maiman did personally get enriched from this money. And then the cross-examination by defense counsel leads to those admissions as well in his January 2020 deposition. I know you've objected to everything that's outside the extradition request on the ground that it's contradictory. Do you think that evidence of Maiman's personal benefit is contradictory to the government's evidence?
I do, but I think that the bigger problem with the cooperation agreement is that it's only going to Toledo's defense, which is that it was Myman and not he who committed this conduct. And Santos clearly says that evidence going to that kind of defense, particularly one that's premised on an argument of credibility, is not admissible in an extradition proceeding. I also wanted to address the claim about all the money filtering to Ecoteva. I mean, I think a lot of defense counsel's argument is premised on the notion that Myman was controlling Ecoteva through the nominee agreement, but that argument falls flat given Myman's testimony that he actually didn't control the company. If in his explanation as to why there was the inconsistency in his statement in that regard. I think it also goes to the testimony about trying to cover up the Ecoteva connection shows the lengths to which Toledo was willing to go to try to conceal the connection between the Odebrecht money and himself. So, I mean, I think given all this voluminous conduct or voluminous evidence connecting Toledo to the bribe agreement and to the money, there's only one answer, which is that there is more than ample probable cause that Toledo committed collusion and money laundering. And to find otherwise, this court would have to improperly engage in a credibility determination. It would have to find that Barada isn't credible. It would separately have to find that Myman is not credible. And it would have to reject all of the other evidence that demonstrates Toledo's criminal conduct. So unless the court has further questions, I would just conclude by asking that the court should deny Toledo's motion to deny extradition based on probable cause. And I would also say, I would request noting that the court has rejected Toledo's other arguments in defense of extradition and that Toledo hasn't otherwise contested the requirements for certification. I would ask that the court also find that all 5 requirements for certification have been met and issue an order finding the same, certifying the request for Toledo's extradition for consideration by the Secretary of State.
Alrighty, thank you, counsel. I appreciate the argument from both sides. I will take the matter under submission and I will hope to get a written decision out within a few days. The matter stands submitted.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, everyone. We're off the record. Court is in recess.
Recording stopped.
Mr. Toledo, you can hang up now, please.